You can stand at this podium if you wish to inquire.
Could you state your name, please?
Roderick Lazar Thomas.
And Mr. Thomas, how are you? Are you employed at this time?
Yes,
How are you employed?
I'm employed by KBR Wiley, a contractor, a government contractor
Now, where do you live?
at 6238 Kinney Road on the west side of Jacksonville.
And have you allowed Mr. Dyal's RV to be placed on your property?
Yes, I have.
And how close is this RV to your house?
It's within 15 feet of the house.
And do you have any children?
No, well, I have adult children,
Okay, but no minor children.
no minor children.
Are there any minors that live at your household?
No,
To your knowledge, are there any minors that live, minors or schools or anything near your property?
no, not within several hundred feet at the least I know of.
And with, if Mr. Dyal were to live in that RV, would you be able to, you and your family be able to make sure that he was there and wasn't, as opposed to anywhere else?
Yes, certainly.
And this, where was the location of this property again, please?
6238 Kinney Road. It's an acre and a third, I think, acre and a third, or acre and a half. It's a long piece of property.
And you have given permission for Mr. Dyal to live in that RV next to your house?
Certainly.
I have no other questions for this witness, Your Honor.
All right, thank you. State any cross for the witness.
Mr. Thomas, how long have you been friends with Paul Dyal?
About 39 years.
And have you been a member of his church during this time?
Yes, I have.
And for how long have you been a member of the church?
About 39 years.
And over the course of these 39 years, have you been aware of any sexual abuse allegations against any of the church members?
I've been aware by, you might say rumor, of some, probably 25, 30 years ago.
And are you aware any of these were ever reported to law enforcement or DCF?
Yes, I believe in one case, I believe there was at least one case.
And you stated that Mr. Dyal's RV is currently parked on your property?
Yes,
And it's a large sort of like tour bus?
sort of, yes. It's a 35-foot RV.
And obviously the RV is mobile.
Yes,
And are you aware that Mr. Dyal would, Paul Dyal would take it on long trips around the country?
you mean in the future?
Or that he in the past has taken it to many states throughout the country?
Yes, that's what it's for.
Okay, no further questions.
All right, is there any redirect?
No.
All right, thank you. Mr. Thomas, you may step down, sir. All right, do you have any other witness you wish to call?
Yes, Your Honor. Sean Dyal.
Sean Dyal? Okay, if you'll come forward and be sworn.
I do.
Hey, I'm gonna put you on FaceTime until you get in.
Excuse me, if you're on Zoom, you need to mute. Thank you. All right, you may proceed.
Could you state your name, please?
Sean Dyal.
And Mr. Dyal, what is your relationship to Paul Dyal?
He's my father.
So, Mr. Dyal, how old is your father?
He is 70. Yeah, 74, I believe. No, I'm sorry, 78.
That's okay with your father. Now, if your mother and you got the,
I know, I know.
and what's his health?
It's not good.
Are you aware of the diagnoses?
He has had 2 heart attacks, open heart surgery. He has high blood pressure, sugar diabetes, neuropathy, and other things. Has long-term COVID, had COVID year before last, and has breathing problems and lung issues because of that are ongoing.
Now, obviously you want to see your father come home, but you understand that one of the obligations of any kind of release the judge would give would be to make sure that Paul appeared in court.
Absolutely.
And that he didn't have any. I'm sure there would be restrictions such as having no contact with minors.
I do understand that.
When would you and your family be willing to make sure that he followed any conditions that the court may impose?
I would, and I'm sure my family would as well.
I have no other questions.
All right, thank you. Any cross-exam?
Mr. Dial, did Paul Dial travel in February of 2022 in the RV type bus to Texas?
He did.
And so during that time, just 2 months ago, he was well enough to travel?
He was sort of. It took him way longer than it should have because of his physical condition. And he had to take his breathing machine for oxygen with him. And he shouldn't have traveled, but he did. And because of that, his journey was very hard on him. And he actually regretted making the journey when he did because of his health.
Okay, but he did just travel in February of 2022.
Yes, he did.
No further questions.
All right, is there any redirect?
No.
All right, thank you. Mr. Dahl, you may step down, sir.
Thank you.
Do you have any other witnesses you wish to call? Dave, do you have any witnesses you wish to call?
Yes, Your Honor. The state would call Detective Diane McClellan.
All right, detective, you'll come forward and be sworn.
I do.
All right, you may proceed.
Your Honor, would the court please take judicial notice of Detective McClellan's affidavit that was filed and attached to both of the state's motions entitled Response to Defendant's Motion to Set Bond and Motion for Pretrial Detention?
Yes, that will be done. That's been filed in this case.
Yes, Your Honor.
Thank you.
Please state your name.
Diane McLennan
Where are you currently employed?
with the Jacksonville Sheriff's Office.
And how long have you been employed there?
Almost 7 years.
Where are you currently assigned within the Jacksonville Sheriff's Office?
The Special Assault Unit.
And how long have you been assigned there?
A little over 3 years now.
And are you the current lead detective on this case?
Yes, ma'am.
Was there a detective handling this case before you?
Yes, ma'am.
And have you reviewed all of the prior detective reports?
Yes, ma'am.
And did you draft an affidavit in conjunction with this hearing detailing your investigation of this case?
Yes, ma'am.
Detective McLennan, were you present for the execution of the search warrant in this case at the Body of Christ Church?
Yes, ma'am.
And is Paul Dial's residence located on the second floor of that church?
Yes, ma'am.
And does Paul Dial have a large tour bus that he uses to visit other affiliated churches around the country?
Yes, ma'am.
And during the execution of the search warrant in this case, were many items seized by the Jacksonville Sheriff's Office?
Yes, ma'am.
Have all of those items been reviewed at this point?
No, ma'am.
And are some of the items, for example, electronics, still being processed forensically?
Yes, ma'am.
And are all of the items that were seized by the Jacksonville Sheriff's Office still needed as a part of this ongoing investigation?
Yes, ma'am.
Have you spoken to the victims in this case?
Yes, ma'am.
Did almost all of them tell you that they suffered physical and psychological abuse from Paul Dyal?
Yes, ma'am.
Did they describe getting beaten with a wooden paddle?
Yes, ma'am.
Did you recover any wooden paddles during the execution of the search warrant?
Yes, ma'am.
How many did you recover?
There were 2.
And did they match the description as described by the many victims and witnesses in this case?
Yes, ma'am, they did.
And did the victims in this case also suffer sexual abuse from Paul Dyal?
Yes, ma'am.
Are they fearful of Paul Dyal?
Yes, ma'am.
Are they worried for their safety if he is released from custody?
Yes, ma'am.
Are the initials of the main charged victim in this case CV?
Yes, ma'am.
Describe the emotional state of CV when you interviewed her.
At first, CB was hesitant due to her fear of retaliation and not knowing who I was at first. And then once I met with her in person, she was able to build trust with me, to put a face to my name and my badge. And then once that bond was created with her trust, she was able to speak with me about her experience.
And was it the years of physical and psychological abuse and sexual abuse that made her, in your opinion, so fearful to speak with you
Yes, ma'am.
and so fearful for her safety?
Yes, ma'am.
Going back to the execution of the search warrant, when you executed the search warrant at the church a couple of months ago, about how many children were at the church during the execution of that warrant?
It was approximately 10 to 15 children.
And throughout the course of your investigation, have you also learned that Paul Dyal was traveling to other affiliated churches out of state?
Yes, ma'am.
And where are the locations of those churches?
It's throughout the United States.
And as recent as February of this year, did you learn that he traveled to Texas?
Yes, ma'am.
And has the defendant recently mentioned moving out of state if he is released in his jail calls?
Yes, ma'am.
Did you learn throughout the course of this investigation if Paul Dyal had a position of authority in the national church outlets, meaning the Assembly Church group as a whole?
Yes, ma'am, I did.
And what did you learn about that position of authority?
That he was a part of the leadership group, which was approximately 12 to 13 leaders over the actual assembly.
And that's across the United States.
That is correct. Yes, ma'am.
And during the course of this investigation, did you also discover that there were multiple allegations of sexual abuse involving other elders in the church, involving other members of the church?
Yes, ma'am.
And did you learn that many of the church members were aware of these allegations
Yes, ma'am.
and that they have been aware of them for decades?
Yes, ma'am.
Did Paul Dyal's wife confirm to you that she was aware of these allegations?
Yes, ma'am.
Were Vernon Williams and Jerome Teschendorf two of these elders that were alleged to have sexually abused children?
Yes, ma'am, they were.
And did you learn that Jerome Teschendorf was welcomed back into the church after he was arrested for sexual misconduct?
Yes, ma'am.
And Paul Dyal was the leader of the church at this time, correct?
Yes, ma'am.
And Jerome Teschendorf was allowed access to many children at this time.
That is correct. Yes, ma'am.
And he was living on the actual church property at that time, correct?
Yes, ma'am.
And did all of the witnesses that you spoke to in this case, victims and witnesses, confirm that Paul Dyal was in charge of the church for the past 30 years?
Yes, ma'am.
No further questions for this witness at this time, Your Honor.
All right, thank you. Is there any cross?
Detective, you said there were 10 to 15 children in the church.
That is correct.
Were any of those children seized by VCF or?
To my knowledge, no.
And now, as far as you said that Paul Dyal traveled. Have you ever
Yes, sir.
visiting other churches?
Yes, sir.
Have you ever traveled out of the state of Florida?
Yes, sir.
But if you were told by the sheriff or by Judge Southward not to leave, would you leave?
No, sir.
All right, thank you. Is there any redirect? All right, thank you. Please step down.
Thank you.
Thank you. All right, State, do you have another witness to call?
I do not, Your Honor.
Okay. All right, so this is as to the motion to set bond, since it all kind of goes hand in hand on the motion for pretrial detention. Are there any witnesses that either party wishes to call? It's the state's motion, so I guess I'll ask you first. Any additional witnesses?
No, Your Honor.
Any witnesses on behalf of the defendant?
No.
All right, then let me hear argument. I'll start with you, sir, for the defense.
I'm just making sure the court here.
You can stand right here at this podium with the microphone. Thank you.
Your Honor, the primary purpose of bail.
Not an H-O or? Well, wait, why can't I?
Okay. I need everyone on Zoom to mute if you're going to observe. Thank you very much. All right, let's begin again.
Your Honor, the primary purpose of bail is to ensure that the defendant appears in court and that, and the safety of the community. Paul Dyal is, suffering from numerous medical conditions, which is difficult for him to be treated in the jail for. It would also limit his ability to be a threat to any outside parties. Now, his friends and family have set up a place for him to live, not be near any minors, that will not, allow him to be observed by other people to make sure that he appears in court. I understand the state's concern that the place they have him staying in is an RV, and that he has previously traveled, but both his family and the church members are all willing to make sure that he appears in court and that he does not leave the state if that is what the court wishes. He is also amenable to any kind of GPS monitoring the court may wish, which would further limit his ability to leave, I believe, even Duval County with the way the monitoring system works. We're asking that the court set a bond in the case so that Mr. Dyal can get out and continue to maintain his health while he is challenging these charges.
Okay, thank you very much. Let me hear from the state.
Your Honor, as the court is aware, the defendant is charged with 2 counts of capital sexual battery. Each count is a capital crime punishable by mandatory life in prison. The primary purpose of a bail hearing in a capital case is to determine whether or not proof of the accused guilt is evident or the presumption great. In State v. Arthur, the court held that if the proof is evident or the presumption great that a person accused of a capital offense or an offense punishable by life imprisonment is guilty of the offense charged, then the accused is not entitled to release on reasonable bail as a matter of right. The standard as found in Arthur is that viewed in the light most favorable to the state must present some evidence that would be legally sufficient to sustain a jury verdict of guilty. This evidence may be presented in the form of transcripts or affidavits. The court took judicial notice today of Detective McLennan's affidavit outlining the sexual abuse allegations against the defendant of victim CV and of the other two Williams Rule victims in this case. So a total of 3 allegations of sexual abuse against this defendant. This evidence is more than legally sufficient when viewed in the light most favorable to the state to sustain a jury verdict of guilty. And while the state believes that we have met this standard, the court still has discretion to provide bail to the defendant. And so the court looks at the other factors laid out in Florida Statute 903.046, Florida Rule of Criminal Procedure 3.131, and Florida Statute 907.041. These are the additional statutes that outline reasons for when a court may deny bail. The purpose of a bail determination in a criminal proceeding is to ensure the appearance of the criminal defendant at subsequent proceedings and to protect the community against unreasonable danger from the criminal defendant. The court may also consider the nature and circumstances of the offense charged, the weight of the evidence against the defendant's family ties, his financial resources, and the nature and probability of danger which the defendant's release poses to the community. The court may also consider the nature and probability of intimidation and danger to the victims and any other factors that the court finds relevant. The defendant in this case is a leader in the Assembly of Christ churches. There are hundreds of these churches throughout the country. There are dozens in Florida alone. The defendant has ties to the Jacksonville Assembly Church here, but also has many connections throughout the country, as evidenced by the defense's own packet that they provided, where pastors throughout the country wrote letters on his behalf. He has a large tour bus at his disposal that the court is aware he recently took this past February to Texas. And per the property appraiser's website, which is public record, the church property is valued at over $2 million. The state is concerned that if released, the defendant would attempt to leave the state and possibly seek refuge in any of these other churches located in remote locations throughout the country. The state is also concerned for the defendant to remain on church property or live at the Kenny Road property location that was mentioned today. The defendant lives on the second floor of the church, so there is no way to keep him away from children that attend the church. In addition to the sexual abuse allegations, the defendant is also alleged to have physically and verbally abused members of the church for over 30 years. Many of the victims and witnesses are intimidated by the defendant and are fearful of him being released. The defendant was in a position of trust and power, and he abused that power to prey on innocent children. The charges against him show a complete lack of and disregard for the safety of the community. The only way to protect the community from this defendant is to deny bail. As mentioned previously, the state fears that he may try to leave the state if granted bail. An ankle monitor or GPS will not protect the community because the defendant lives above the church and has access to all of the children that attend the church. He also has many grandchildren. Additionally, and as evidenced by the letters received in support of the defendant, his own family and many people who still attend the church do not believe the allegations against the defendant are true, and therefore cannot be trusted with protecting their children from the defendant. The state has met its burden under the Constitution and all of the statutes that I have previously referenced, because there is no way to adequately protect the community if the defendant is afforded bail. Additionally, the victims in this case are extremely scared for their safety and want the defendant to be denied bail to ensure that the community is safe and that the defendant doesn't abscond. Therefore, we would request that the state deny the defendant's motion and grant our motion denying his bail.
All right, thank you. And you have the last word, rebuttal.
Yes, Your Honor. As the state mentioned, Florida statute 97041 covers the issue of bail. And it specifically says that the presumption is actually for non-monetary, at which point then would be monetary, and then of course would be incarceration, but are no bail. We are simply asking that he not be incarcerated. We expect and the court would set some type of monetary bond. And of course, other conditions that the court feels is necessary to ensure both his appearance in court and any safety issues. The state repeatedly mentioned that his home is over the church. He is not planning on returning to the church property. He understands that's more than likely to be one of the conditions. And the fact that the accusation that he might seek sanctuary at one of these other churches just because he was the leader of it. This is to basically accuse the entire organization of being a criminal organization. Even if we were to, in arguendo, accept that Mr. Dyal is guilty, that doesn't mean that the entire Assembly of Christ is a criminal organization. And yes, these people don't doubt the charges. They believe that he is innocent until he is proven guilty, which we do, although the state has provided evidence that showing, some tendency towards guilt, we have obviously not reached the stage yet where it's been determined if he is in fact guilty. And we ask that the court allow him the opportunity to have some form of bail and conditions that he might be able to make.
All right, thank you. All right, I have considered the testimony I have heard today, the argument of counsel, of course, your respective pleadings, the motion to set bond by the defense and the response thereto filed by the state, along with and in conjunction with the motion for pretrial detention filed by the state. I have taken judicial notice of the affidavit by Detective McLennan, which outlines the evidence to date. And while I agree with you, this is not the trial. I am not the finder of fact in terms of guilt beyond a reasonable doubt. But what I'm being asked to do today is to look at the nature and circumstances of the offense and to consider the crimes charged and all those many other factors outlined in Florida statute to determine whether or not Mr. Dyal is entitled to bond. As you all well know, he is charged with 2 counts, and they are capital offenses that, if convicted, would require mandatory life sentences to be imposed by this court. Having considered the evidence in the affidavit and the factors outlined in 903.046, along with the dictates of the Arthur case, at this time, the court is going to deny the motion to set bond and to grant the motion for pretrial detention, having found the relevant evidence to be sufficient and the factors outlined by the testimony I've heard today to weigh in favor of that decision. So I will get written orders out as to each of those. That does, however, leave the defendant's motion for return of property. I don't know if either side has additional evidence or arguments it wishes to make with respect to that motion. I did, of course, hear a little bit from the detective with regard to the items that were obtained as a result of the search warrant. But is there anything else that either side wishes to present? It is your motion, so you can go first.
Only, Your Honor, that we understand that any items that might there still be examined. Sheriff's office will want to be just asking for those items that are not at least to be returned. Most of the things, a large portion of things that we're taking are actually property of the school. And they like to get that stuff back. Anything that is still being examined, we understand the state is going to want to keep.
Okay, and by my review, of course, of the motion and there is outlined items from A to double V, so quite a number of items, many and most of which seem to be electronic in nature, computers, laptops, disks, towers, whatnot. So presumably thumb drives, computer towers, DVDs, CDs, cassettes, those need to be forensically examined.
We're just asking that once that is done, assuming that they have no, the state doesn't find any of that shit, they need to return.
Okay, is there any objection?
Obviously, if there's something on there that the state feels is evidence, then presumably.
Right. Once the analysis is completed, those items that do not have or are not evidence in this case, does the state agree to return those?
Yes,
Okay. All right, so with that, I guess at this time, I'll just deny or partially deny, partially grant your motion. Denied in that the items being analyzed will not be returned at this time. Granted, to the extent that they are analyzed and are not evidence, they will be returned. I'll get an order out on that as well. Are there any questions about the court's rulings today? Okay. I was asking the lawyer, sir. I'm sorry, not the audience. All right, let's pick the next court date then for Mr. Dyal's pretrial conference. What otherwise is happening in the case at this time? And how much time do you need until the next audience before the court?
Judge, we still have ongoing discovery reports that we are trying to get. We have given the majority of it to the defense, but I would probably suggest we schedule a conference between the two of us to make sure that they have everything that they need. So maybe 3 weeks from now.
All right, I can pass this matter then until May 18 for the next pretrial conference. 3 weeks from today. Does that work for both sides?
Yes, Your Honor.
Yes, sure.
Okay. And that will be the next court date. Thank you very much.
Thank you, Your Honor.
I'll tell you. I just didn't. I'll tell you. All right, we're in recess until 3, and then we have the McCrae case.